Court does call the case of the People's State of Michigan versus Willie Eugene Collins.
We're ready in that matter.
We open on a probable cause conference, a procedural stage that often moves quickly but carries real consequences. This is not trial. This is not sentencing. This is positioning. The defense immediately signals a negotiated resolution. A plea form has been signed. That means conversations have already happened behind the scenes. Offers were exchanged. Risk was evaluated. In criminal court, this stage is about narrowing exposure. If a defendant can trade uncertainty for predictability, many will, especially when a felony is involved. Watch how efficiently this is handled. No theatrics, no prolonged argument, just confirmation of the agreement and judicial review. This is what high-volume criminal dockets look like. Quiet decisions, major consequences.
Good morning, Your Honor. For the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willie Collins. Mr. Collins, please state your name for the record.
Willie Eugene Collins.
All right. Your Honor, today is the date and time set for the probable cause conference. I've discussed with my client and misdemeanor offer, which has been offered in this case. I have, with his consent, assigned a advice of rights plea form, and we also have the plea form now.
Okay. Right. Plea form indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the one-year offense. Upon his successful plea, the felony charge count 1 would be dismissed. Looking at the form, that's the court's full understanding of the agreement.
That's correct.
As I understand, Your Honor, my client is ready to be sworn.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record.
Willie Eugene Collins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, sir.
Now Judge Simpson moves into constitutional compliance. This part matters more than it looks. He must ensure the defendant understands maximum penalties. The plea is voluntary. No improper promises were made. No coercion occurred. Every yes, sir creates a record. If this defendant later claims ineffective counsel or misunderstanding, the transcript will show direct confirmation of comprehension. Also notice, sentencing will occur before another judge. That preserves neutrality. The judge accepting the plea is not necessarily the one imposing punishment. Procedure is protection for both the defendant and the court.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You had an advice of rights form explained to you
Yes, sir.
and gave permission for your counsel to sign it?
Yes, sir.
All right. Do you have any questions regarding any of those rights?
No, sir.
You understand that by entering this plea that you're giving up your rights as contained in paragraph 5, your trial rights?
Yes, sir.
All right. You understand also you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty?
Yes, sir.
July 26, 2023, at the location of 501 East Michigan Avenue in the city of Ypsilanti, Washtenaw County, state of Michigan. Did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
This is the factual basis portion of the plea. Courts require defendants to admit facts that satisfy the elements of the crime. Without this step, a plea can be invalidated. The judge confirms location, date, possession, knowledge. Those admissions close the loop legally. Notice how minimal the answers are. No narrative, just confirmation. That's intentional. Once the court accepts the plea and dismisses the felony count, this case shifts towards sentencing and probation evaluation. One case resolved in under 4 minutes. Now the docket shifts and the tone changes.
Did you know what you were using was methamphetamine?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
The defense is satisfied, Your Honor. Thank
Court
you.
will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this case will be
At 10 a.m. before Judge Barr.
May 14, 2025. I'm sorry,
10 a.m.
10 a.m. before Judge Barr.
Thank you very much.
Bond will continue. Thank you. Thank you, Mr. Collins.
I'll be in touch, Mr. Collins. Okay.
Court calls the case of the People versus Chalice McLaughlin.
Andrew Childers appearing on behalf of the
An assistant public defender, Tanaza Carey, Your Honor, on behalf of Mr. Chalice McLaughlin.
Sir, can you please state your name?
Chalice McLaughlin.
Thank you.
Judge, we respectfully request that this matter be set for preliminary examination, please.
All discovery is complete.
To our knowledge, Judge.
What the? It makes sense. What? I don't know that they have to do a writ. You're not gonna have to do a writ on this. Bill will come get him or go get him, right?
So he's being housed there from.
I think he's being housed in Saginaw, but not by Saginaw. We're housing.
I would, we could maybe just have an extra week, just in case.
We don't have a problem with that, Your Honor.
On the 13th, all right. Discovery is complete. I will set preliminary examination will then be set May 13th, 2025, 9 a.m. before me. That'll be in person. Bond will continue.
Thank you, Your Honor.
Thank you. It's 13th. No, it's the 6th. That's it. All right. Thank you. Thank you, sir. Court calls the case People versus Seth Priester.
If you're ever to me, doesn't.
This is
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
Priester, can you state your name, please?
Seth Priester.
Thank you. All right, what are we doing in this case?
Your Honor, I'll set it for an exam.
All discovery is complete?
Yes. I believe so. I have both electronic and paper.
There are 911 call. You have that?
I don't know. Just accepted the case 2 days ago. They just sent me the discovery yesterday evening. But I believe we have enough because I have.
Is all the discovery complete?
As far as the people know, Your Honor, there's a co-defendant in this case, just so the court is clear.
Co-defendant.
Also on today's docket, I have that as Debassier Hennings.
Who's representing? You're representing him?
Yes, there's a conflict in the case, so.
So you're not representing him?
I believe we're still the attorney right.
Ms. Constantino did ask me about it earlier. She's in the court.
Where is she?
She's on today's docket. She might be meeting with the client or in the hallway.
Might be next year.
Where is she? She's so small. We don't see. So is she in the room or no?
No, no.
Okay. Okay. In speaking with her, were you under the impression she was also going to be asking for an exam?
She was not. She just got appointed, I think, like this morning, and she hasn't even gotten discovery or anything yet.
All right. Ms. Barnwell, you want an exam?
Yes, Judge.
People have their witnesses available the 6th.
We'll certainly try our best, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. before Judge Perry.
One split second, Judge. I'm not available on that day, Judge. I'm available on the,
Why don't we do this? Let me pass this matter briefly. Why don't you go talk to Ms. Constantino, since these are co-defendants? I would rather, if we can, through some judicial efficiency, get a date that this can be heard where both defendants can be heard.
okay, Judge.
All right. Mr. Priester, hang in there. I'm going to pass your case for a moment. All right?
Yes, sir.
Thank you. Court calls the case, People versus Stephen Smith.
Richmond, Deputy People on all four.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Smith.
James Feifels, appearing on behalf of Mr. Smith in file ending with 5506.
Oh, I apologize, Your Honor. I'm on the rest.
Yes, sir.
Just in case you didn't know.
What are we doing?
Your Honor, I believe all discovery is in and we are asking the court to set these files for preliminary examination.
That is correct, Your Honor.
People have their witnesses available on the 6th.
We will try this one.
Preliminary examination in person, May 6, 2025, 9 a.m. before. Oh, joy. Okay, 12 p.m. That's before me. That's at 12 noon.
Thank you.
Bond in these matters will continue.
Thank you very much, Your Honor.
Court calls the case, People versus Arthur Herndon.
Apparently, Zed on behalf of the people, Your Honor.
Folks, on the PD side, you're gonna have to make sure that that aisle is relatively clear so they can get through.
Good morning, Honor. Rob Jekyll on behalf of Arthur Herndon. Arthur, state your name for the record.
Arthur Herndon.
Thank you.
You already said that? Oh, I'm sorry. Judge, today's a PCC. I met with Arthur last night. We had a long conversation. We want to set this matter for exam, please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 6th.
We'll do our best, Your Honor.
Preliminary examination in person, May 6, 2025.
Judge,
Right.
can I briefly address bond?
As soon as I'm done.
Okay.
9 a.m. That is before Judge Perry. As to bond.
Judge, just very briefly, it's my understanding the bond's $50,000. This incident is between he and his significant other. I understand the situation. She came to where he was staying and an argument started. There was a no contact order between the two. He tried to get away saying there's no contact order. I'm not excusing some of his conduct, but the bottom line is, Your Honor, I just think this whole incident was provoked by the victim in this matter, who are both these parties are in juvenile court on another matter. And it escalated. And I'm just asking if the court would consider a 10% bond, Your Honor.
Response.
People have a strong objection. In this case, the victim wasn't the residence, which her name is the only name on the list to get some of her belongings. She was letting the defendant stay there. When she got there, he repeatedly punched her in the face with a closed fist. He then put her on the ground and kicked her, then put one hand on her neck and applied pressure. She had trouble breathing. He also took her phone, which she believed was to stop her from calling 911. The phone was then found on him when he was arrested.
Now we enter a bond argument involving alleged domestic violence, and the prosecutor is deliberately detailed: punches, choking, pressure on the neck, hospital transport, concussion concern, follow-up bruising. Those specifics are not accidental. They frame the defendant as dangerous. In bond hearings, judges consider severity of alleged conduct, risk to alleged victim, criminal history, community safety. Strangulation allegations are especially serious. Courts recognize the elevated risk profile in those cases. The defense attempts reframing, provocation, escalation, mutual conflict. But bond decisions hinge on risk, not proof beyond reasonable doubt. This is the court's first risk assessment of the day involving violence.
The victim was eventually able to get away from him, run to her car where he followed her, punched the windshield damaging and also ripped inside her car. When officers arrived, he ran from them and had to be taken to the ground to be arrested. I just had extreme concern. She was transported to the hospital for a possible concussion. She had abrasions to her chest, her forehead, her shoulder, her lip, redness all over her neck, and then bruises days later from follow-up photos. This is an extreme act of domestic violence, and I'm great concern. And then he also has the child abuse case up in 22nd Circuit Court.
Judge, just very briefly, this whole incident happened over this child abuse case, Judge. And the fact of it is, she accused him when she found out, never mind, it's a long story. She took his phone. That's why he followed her, asking for his phone back. I know you've heard a lot of stuff. I'm just continuing to ask for a 10% bond. Before this had happened, before she had found out that she came to him, Judge, and the whole thing started when she argued with him. She would not leave. Granted, she was letting him leave in her apartment. She was able to live somewhere else. But again, it's not anything that he initiated, Judge.
The punching wasn't?
Judge, he was defending herself when she came at him with a knife.
Okay.
Your Honor, I also have concerns because in that child abuse case, she did report that there was past events of domestic violence that she did not report because she was scared of the defendant. So I have great concerns of their history and this event.
Anything else? Motion for bond reduction is denied.
Thank you, Your Honor.
Court calls case People versus Danielle Hinton. Oh, there's long lost Constantino. No, I'm telling you, Feaster said you were so short, I just wasn't seeing you. I'm just telling you what he told me. I'm telling you what he told me. Anyway. All right, that's right, Feaster, you deal with that. Okay. Hey, I'm just saying I'm just letting her know what happened. All right.
Just a record of this.
Go ahead.
Should we put
Go
my
ahead.
appearance
I
now?
called the case.
Good morning, Judge Wendy Burnwell, P42-505, on behalf of Miss Danielle Hinton, who's standing to my right.
Ma'am, can you state your name, please?
Danielle here.
Thank you. What are we doing on this case?
Your Honor, I don't have electronic discovery on this one. I have paper discovery.
We can get the discovery over to her probably by next week. Your Honor.
All right. Do you want an adjournment of this?
Yes, Judge.
All right. I'll need a green sheet. Probable cause conference in this matter will be adjourned.
Now we see a procedural adjournment. Discovery is incomplete. That's significant. Defense cannot meaningfully evaluate a case without full evidence, reports, videos, statements. Courts are careful not to push cases forward prematurely. Due process requires informed participation. An adjournment here is not delay for convenience. It is preservation of defense preparation rights. Notice the efficiency again. Green sheet, new date, bond continues. These moments may seem routine, but they protect the integrity of later proceedings. Preliminary examinations and pleas must be informed decisioned, not rushed.
I'm sorry.
You're not available May 6th?
Only in the afternoon, Judge. And she's out on bond.
So I'll adjourn this to May 15th. 2025, 9 a.m. Bond continues. Thank you.
Thank you, Judge.
Thank you, Ms. Henry.
That's for the PCC, correct?
That is.
All right.
I'll need a green sheet. Form that matches your code. Court calls case People versus Jacob. Is it Brooks? Probably be mispronouncing that, but might be Brio.
Sherilyn Foster Tucker on behalf of Jacob Bro.
Recognize the name with the spelling. Rachel McDuff for the people on this matter.
What's your name, sir?
Jacob Allen Bro.
It's pronounced Bro?
Bro, like B-R-O.
Yeah, that's what I thought you said. That sounds, okay. Thank you.
And Your Honor, we're requesting a preliminary exam in this matter,
All right, and all discovery is complete?
to my knowledge.
People have their witnesses available on the 6th?
Your Honor, could I
Yeah.
get the following week, actually? Sorry, I'm not
13th.
available on the sixth.
People have their witnesses available the 13th.
We'll try our best like that too.
Preliminary examination in person, May 13th, 2025, 9 a.m. That's before Judge Valvo.
This marks the shift into exam scheduling territory. A preliminary examination is not trial, but it is the prosecution's obligation to show probable cause. That means presenting enough evidence to convince a judge that a crime likely occurred, the defendant likely committed it. Defense attorneys sometimes request exams to test witness credibility early. Sometimes they request them as negotiation leverage. Setting the exam date locks both sides into preparation mode. The docket so far reveals a pattern: plea resolution to bond battles to discovery adjournments to exam settings. This is criminal court rhythm, and we are only about 1/3 through the session.
Bond in this case will continue. All right.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Jenny Lou. There she is.
Michael Getty, Assistant Public Defender on behalf of Ms. Lou, Your Honor.
Lou, can you state your name, please?
Yes, sir. Jenny Lou.
Thank you.
Your Honor, I have had a chance to speak with Ms. Blondie. There is a global resolution that I think that I haven't been able to confirm that Ms. Lou's aware of, that would resolve this and the other matter that both matters that are pending here. And I think there's already been a plea in a matter, in a misdemeanor matter. To the extent that I haven't had a chance to talk to Ms. Lou about it, I'd ask the court for a brief adjournment. I know there might be writ issues. I would be willing to do a week. I'll make sure I keep.
I can't do it.
I understand, Judge. But I would, I'll make sure I keep this case so I can go visit her at the correctional facility and go over this with her.
I don't even, it's gonna have to go to May 15th with the adjournment. I'll need green sheets.
Oh, I'm sorry. Yes, I'll do a green sheet, Your Honor. But I'll make sure I keep this case so I go see her.
All right. So probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Thank you. And I'll come visit you next week, Ms. Lou, okay?
Are you already like on your way? Because it's gonna take a while for the visitation to go through.
Oh, yeah.
So have you got the process?
Yeah, I know the process. I'll come visit you in person, okay?
You've already started the process though, sir?
This exchange is subtle but revealing. The defendant wants confirmation that her attorney will physically visit her in custody. That's about trust. Incarcerated defendants often feel disconnected from case progress. Communication delays create anxiety. From a legal standpoint, in-person consultation before plea or exam is critical. Counsel must explain discovery, potential defenses, sentencing exposure, and negotiation options. Notice the judge doesn't interfere here. This is attorney-client logistics. But the court does set a firm new PCC date. That keeps the case moving. This moment highlights the human dimension of criminal proceedings. Behind every docket number is someone waiting in custody, unsure what happens next.
No, but I will be able to get there very quickly.
So you won't be here next week. You'll be here in like 2 months. All right. Okay. Thank you, sir.
All
All right.
Okay.
Thank you, Ms. Lou.
Thank you, Your
I'll
Honor.
go visit her. That's it. And I'll do those briefs.
Court does call the cases of the people versus Kyle Burmeister.
People, Your Honor.
James Feifels, appearing on behalf of Mr. Burmeister on the file ending in 5028.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Burmeister on the remaining files, Your Honor.
Can you state your name, please?
Kyle Burmeister.
Your Honor, I believe we have an agreement of sorts with Ms. Zenda. We're asking the court to, 1, adjourn for 3 weeks, 2, modify bond to allow him to be released to inpatient treatment with a tether.
This is strategic bond modification. The defense isn't asking for simple release. They're proposing inpatient treatment with tether monitoring. That reframes the defendant not as a threat, but as someone addressing underlying issues. Courts often view structured treatment favorably, especially when substance abuse contributes to alleged conduct. The judge responds pragmatically, prepare an agreed order. That indicates conditional approval pending paperwork. Bond conditions can include tether monitoring, inpatient rehab, no contact provisions, travel restrictions. This is a preventive model. Supervision instead of detention. Judges balance public safety with rehabilitation opportunities. Treatment-based release is often seen as proactive risk reduction.
All you have to do is prepare an order. I'll sign that if it's agreed to by the parties.
Okay. So in that case, then we're asking, I believe 3 weeks would give us some time to hopefully negotiate a resolution.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will
We
continue.
gotta give him a call. You can have somebody help you call them.
I did. So all the other. Pretty good.
Thank you, Your Honor.
We'll get
Thank you.
here in the next day or so
Constantino,
Okay.
have you talked to,
on these two files.
The one that was for,
the last person to finish my sentences,
Um,
no longer around.
yeah, we'll have.
Okay, so you guys are ready on that? If I call, okay. Thank you. Court calls case, People versus Brendan Chrysler.
Your Honor, can we pass that a moment? I'm still waiting for him. He had some car troubles. Thank you, Your Honor.
Court calls case, People versus Eddie Gardner.
Richard McGuffin for the people.
What's her other case?
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Mr. Gardner, who is present and standing to my right. Mr. Gardner, please state your name for the record.
Eddie Gardner.
Thank you.
Judge, this is a date and time set for PCC. It's my understanding that discovery is complete to my knowledge, so we would be asking for a preliminary exam.
People have their witnesses available to 6. Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry.
Thank you very much, Judge.
Thank you. Bound continues. Court calls the case of the People versus Michael Hill.
That was for the P727, right?
James Fifelsky on behalf of Michael Hill, who is approaching.
Hello, Your Honor.
Hello.
State your name, please.
Michael Wayne Hill.
Your Honor, this is a first PCC. I'm still awaiting discovery, so I'm asking for an adjournment to May 15th so I can obtain that and review with my client.
You need all the way to May 15th?
It'd be helpful, just since I haven't received anything yet. So if the court can,
May 15th, 2025, 9 a.m. Bound continue.
thank you very much, Your Honor.
Court does call the case People versus Julia Sasinski.
That's the one for the people.
And James Fifelsky on behalf of Ms. Szynski, can you state your name, please?
Julia Szynski.
Judge, we're still trying to get to the bottom of some discovery, whether it exists or not. But I've been asking, and I know the prosecutor's office has been trying to get it from MSP, but we don't have it yet. So if we can do one last adjournment for 3 weeks, I'm hoping they produce or they tell us that it doesn't exist, and then we can move forward.
Just so you're aware, Mr. Hrabowski, and I know you're aware of this, I don't set it for attorney's convenience these dates. May 15th, 2025, 9 a.m. Bound continue.
Thank you very much, Your Honor. Talk to you soon. I'll give you a call once I hear something.
Court does call the case People versus Devin Gibson.
That's your honor. Please, Brandon Bird on behalf of Devin Gibson, PA 3734.
Good afternoon, or good morning.
Good morning.
Your name, sir?
Devin Gibson.
Thank you. All right, what are we doing?
We'd like to set this matter for exam, your honor.
All right, you have all the, all right. You have all the discovery, sir?
Yes, your honor.
All right. People have their witnesses available to 6. All right. Preliminary examination in these matters will be set in person, May 6th, 2025, 9 AM, that's before. At 12 noon, that's before me. Thank you. Esteban.
It's come to my attention that the defendant has made 80 calls to the victim since the arraignment using his pin and other pins.
This moment escalates risk concerns sharply. 80 calls is not incidental contact, it's persistent. The prosecutor emphasizes two things: discussion of the crime, instructions about what to say in court. That second point is critical. Attempting to influence testimony undermines the integrity of proceedings. Even if conversations appear apologetic, repeated jail contact with an alleged victim is viewed as pressure. Courts are extremely sensitive to this dynamic in domestic or personal relationship cases. The judge's response is precise. Monetary bond continues, but phone privileges are revoked. That's targeted intervention. Instead of increasing bond immediately, the court restricts the behavior, creating risk. This demonstrates active courtroom management. The judge is responding to evolving information in real time.
In these calls, no victim, but at first they talk about the crime that occurred here and he apologizes. Also in these calls telling her what to do and say in court. So I have great concerns given that he's contacting the victim from jail. Would ask his phone privileges be revoked.
Anything you'd like to say in that regard, counsel?
No comment, yeah.
All right. Given that his monetary bond will continue, his phone privileges are hereby ordered revoked.
Revoking phone privileges is significant. Jail communication systems are recorded. Prosecutors monitor them. Once the court is alerted to potential misuse, restrictions become likely. From a defense perspective, this is damaging. Jail calls often become evidence. Apologies, inconsistencies, emotional statements, and all admissible. From a judicial standpoint, this order protects the alleged victim, the integrity of testimony. Court authority. Phone access is a privilege in custody, not a constitutional guarantee for unlimited communication. This ruling sends a clear signal. Compliance with bond conditions is mandatory, even while detained.
Thank you.
Thank you, man.
Court calls case People versus James Valcour.
Good morning, Your Honor. Laura Willenberg on behalf of the people.
Good morning again, Your Honor. Christina Costantino appearing on behalf of James Vacalpour, who is present via Zoom. He is coming from the KPEP facility. Mr. Vacalpour, if you're on Zoom, could you ask them to unmute you and state your name?
Pardon?
We have a dial.
There's an individual who's dialed in. Last four digits or last three digits are 465. Can you hit *6 and state your name?
James Vacalpour.
All right, that's it.
Judge, this is date and time set for PCC. At this time, we would be asking to have this matter set for a preliminary examination. And given the nature of how discussions with the people and I have been going, we would ask if the court would consider setting this out a ways, perhaps to the end of May.
That's correct. No objection.
Like the very end of May, like May 27th would that be good?
That would work for the defense.
And discovery is complete. So set preliminary examination in person. That would be May 27th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you very much, Judge.
Continued. Thank you. Court does call the case People versus Kim Perkins.
Good morning, Your Honor. Tim Sachs on behalf of Kim Perkins.
Your name, ma'am?
Kim Renee Perkins.
Thank you.
Your Honor, this is the date and time for a PCC. We're asking for a preliminary exam date. I do have written and video discovery.
You have all the discovery, okay. People have their witnesses available the 6th.
I believe so. Well, we'll try our best.
Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry.
And Your Honor, if I may make a bond reduction motion.
Go ahead.
Your Honor, I'm asking for the bond to be reduced to a PR bond.
Now we enter another bond argument, but this one has a different tone. The defense frames the case as possible mutual combat between mother and daughter. The defendant allegedly called 911 first. Housing has been secured elsewhere. The prosecutor reframes it as felonious assault with a knife. That's a dramatic difference. In bond hearings, narratives compete. The judge is not determining guilt, only assessing risk. When domestic relationships are involved, courts look closely at cohabitation and future contact. If parties still live together, risk increases. If separation is secured, risk decreases. The judge pauses to clarify living arrangements. That detail affects outcomes significantly.
Perkins is here on an allegation of assault and battery with Bridget Williams, her daughter. What I've seen so far in this, at worst, this was a mutual combatant. Ms. Perkins' top was torn off. She actually called 911 first, and then she wound up being arrested. The alleged victim also called 911. So this is not a foregone conclusion that she was the aggressor or would be a further problem. She has secured housing with her other daughter in Port Huron, so she does not need to go back, except for one time with a police escort to get her wallet and a couple of clothes. And she assures that she will be able to attend all future hearings.
Response.
Your Honor, I want to be clear, this is not a matter of assault and battery. This is a case of alleged felonious assault where the victim, Ms. Perkins' daughter, alleged that Ms. Perkins argued with her, fought with her, and tried to stab her with a knife, as well as scratching her face in the course of that incident. I appreciate that she has somewhere else to live. I would
hold on a second. Do they live together?
The victim in this case was apparently allowing Ms. Perkins to stay with her at that residence. And
okay, so they live together. All right, go ahead.
I would ask that bond continue. If the court sees fit to release her, I will request that she have a hot zone tethered to this location. Additionally, I believe that arraignment, there was a request made. I don't know if there's a checking order on this file. Ms. Perkins has a very long history of drug and substance abuse related offenses and convictions. At the time of this incident, she was highly intoxicated and incoherent as well. So I would be requesting that she is tested on all substances possible with some sort of or other device as well, if she would be.
Anything else, Ms. Sachs?
No, Your Honor.
All right. What I'm going to do is I'm going to grant the motion for a bond reduction. I'm going to reduce her bond to a $2,500 personal cognizance bond. I will also indicate that the defendant is to report to community corrections upon her release for placement on a GPS hot zone tether.
This is a nuanced ruling. The court reduces bond substantially, but imposes GPS monitoring and geographic restrictions. That approach reflects modern bail reform principles. Supervision instead of detention when feasible. The judge declines substance testing at this stage because the matter is set for exam. That shows procedural restraint. Bond hearings are not sentencing hearings. Conditions must relate to risk, not punishment. The GPS hot zone creates a technological barrier protecting the alleged victim's location. Violations would trigger immediate consequences. This ruling demonstrates individualized assessment. Same courtroom. Different facts. Different outcome.
Since she's going to be set for exam, I'm not going to order testing at this time.
Thank you, Your Honor.
Court does call the case, People versus Cadavian White.
I'm here.
Christina Costantino appearing on behalf of Mr. White. Mr. White, can you please state your name for the record?
Good evening, White.
Have a camera, sir? Thank you. All right, what are we doing on this case?
Judge, this is a date and time set for PCC. We would be asking for a preliminary exam in this matter. Discovery is complete as to my knowledge.
People would have their witnesses available the 6th. Preliminary examination in person, May 6, 2025 at 12 p.m. That's before me. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of People versus Diversier Hennings. If I'm saying that correctly. And I will also call the case of Seth Priester.
Christina Costantino on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Devasier Henning.
Good morning, Your Honor. Wendy Barnwell, once again, plea 42505 on behalf of Mr. Priester. I don't see him on the screen. I know he's in.
Right.
now.
Could you unmute and then state your name, Mr. Priester?
Seth Priester.
Oh, there.
Thank you. All right. What are we doing?
Judge, I was just appointed on this matter either late last night or this morning. Given that I do not have any discovery at all, actually.
So
So
you're ready to go.
I'm ready to go.
Yeah.
Hey, you know what? I always ready. But given that, to ensure I'm representing my client to the best of my ability,
Yes.
I would be asking for an adjournment of the PCC so I can obtain discovery and review it with my client.
Counsel?
Yes, Your Honor, I will go along with Sister Counsel and I
All right.
believe we'll return on May 15th is our proposed date.
Oh, so you're picking dates.
Just only because I got it from you for the other case.
Yeah, I know, but again. Make that 30 out there, but all right. Ms. Constantino, will the 15th work for you?
Yes, Judge, I can make that work.
Probable cause conference, May 15th, 2025, 9 a.m.
Here we see another adjournment based on lack of discovery. Defense counsel was just appointed. Newly appointed counsel must receive and review discovery before advising a client about plea or exam. Without that, effective representation is compromised. The prosecutor agrees to the adjournment. That cooperation indicates procedural fairness. Setting the new PCC keeps the case structured while preserving defense preparation time. These routine scheduling decisions are foundational. Rushing discovery risks reversible error later.
Bond will continue. I need green sheets on these, please.
Oh, I'm sorry, Judge, I do have it right here. Judge, would the court consider hearing a bond request, a bond reduction request?
I will always hear it.
Thank you, Judge. I'm told my client's bond is currently set at $250,000. We would be asking if the court would consider a lower bond, perhaps $100,000, 10%, with a 10% provision. He is 18 years old. He would be, prior to his incarceration, he had employment lined up at JMB Temp Agency. We are hopeful that he would be able to return or start that employment. He was also enrolled in an adult education GED course that he could continue. Should he be released, he would reside with his mother in Ypsilanti. She's very supportive of him. He has a significant other and a 2-year-old child that he does provide support for. It's my understanding that he does not have any prior adult criminal history, and he would be able to follow any and all no contact orders.
Response from the people.
I believe it's correct that he doesn't have any adult prior history. This is the case with Mr. Priester. He is currently now charged as an adult. The history that I do see is that he apparently.
Mr. Henning.
This is your.
Mr. Henning.
I apologize. Sorry about that. They're called together, I guess. As far as Mr. Henning is concerned, Your Honor, obviously the circumstances of this matter, which would be a co-defendant in an armed robbery case, are concerning on their own. I will leave it to the court's discretion. I did want to ensure that if there's a no contact order on this case, that it does include Mr. Priester. Just, I apologize for misspeaking earlier because the cases were called together, but, Mr. Hennings does not have any adult history as was stated. His juvenile history, does obviously include, not obviously, but includes some counts that were adjudicated in that manner, and he has had, some felony charges, that were pretty serious, I think, resolved with misdemeanors, being unlawful breaking and unlawful use of an automobile, breaking and entering, tampering with the tether. There's quite a bit here. So, Ms. Constance was correct that there's no adult history, but there's quite a bit of juvenile history, here as well. That's concerning. Leading, consistently going from 2020, looks like roughly 5 or 6 cases up through 2025, which is dismissed attempt arrest in terms of activity.
Anything else?
Nothing, Judge. I would just suggest that $100,000 bond would, I believe, would account for even the juvenile history that's been mentioned.
I will, on Mr. Henning's case, I will reduce his bond to 100,000. I will not do 10%. It'd be 100,000 cash surety.
Now we see differentiated bond treatment among co-defendants. The court reduces the bond amount but refuses the 10% provision. That means full cash or surety is required, not a fraction. This distinction matters enormously. A 10% provision dramatically lowers the financial barrier to release. Removing it keeps release possible but difficult. The judge explicitly references juvenile history as concerning. While technically not adult convictions, repeated juvenile adjudications signal pattern behavior. The court is balancing presumption of innocence against risk assessment. One co-defendant receives partial relief. Another's bond reduction is denied entirely. Individualized analysis. That's the operative principle here.
And may I address one for Mr. Priester?
Apparently, yes.
So, Judge, I am pretty sure that, well, I'll rephrase it. I was about to say something. But my client's mother is present in the courtroom. He has been living with her. I know that he was attending a program, I believe, several days in the week over here at Community Corrections, Judge. I do believe that the bond is excessive. And I'm pretty sure that this court understands the concept of a presumption of innocence if the bond is excessive. Thank you.
Response.
So returning to the argument that I was beginning to make earlier, Mr. Priester, in terms of the juvenile history that we have, obviously he's still juvenile today, charges in the adult armed robbery case. It looks like there were 5 previous petition requests in the past year and a half. Unfortunately, those were denied due to some evidentiary issues, I believe. It looks like on the most recent case we have with him, which is the 2024 matter, he did have a plea for home invasion first, UBAA, receiving and concealing a motor vehicle, and financial transaction device theft. So I think we have a plea after that on a separate case for another receiving and concealing stolen property.
Are you saying those are all juvenile adjudications?
It appears to be so, yes. I think this is the first one where he's been charged in adult, if I'm not mistaken. The allegations in this case are not only armed robbery, apparently, that between the individuals involved in this, the victim was pistol whipped in the face.
This is where the seriousness of the robbery allegation becomes central. A firearm placed in someone's face elevates the charge beyond simple property crime. Armed robbery carries severe sentencing exposure and signals potential danger to the public. The prosecutor is emphasizing escalation, not just theft, but use of a weapon. Even if this defendant has no adult criminal history, the court must weigh alleged conduct severity. Juvenile adjudications don't disappear from risk assessment simply because adulthood begins. Courts examine patterns. Repetition matters. Notice how the prosecutor carefully distinguishes between no adult history and extensive juvenile history. That distinction shapes bond analysis. The judge is not deciding guilt. The judge is deciding whether release conditions sufficiently protect the community pending exam. Serious allegations narrow judicial flexibility.
So I understand that this is a juvenile situation, but obviously these allegations and offenses are very concerning. So I would request that.
Anything else?
Your Honor, as to cases that don't meet in the evidentiary threshold, so we still have a constitution that's very active now. And so I would ask, and this court knows, there's a presumption of innocence to this. I don't believe that counsel has brought up anything that's violent or anything of that nature. I respectfully ask that this court lower the bond significantly.
In this case, though, those previous juvenile adjudications in this case, which I think are a distinction between his co-defendant, I am going to decline to reduce the bond in this case. Motion for bond reduction regarding Mr. Priester is denied. Bond will continue.
This denial reinforces judicial caution. The defense invoked presumption of innocence correctly. That constitutional principle remains intact. However, bond decisions operate under a different lens: risk management, not final adjudication. The judge explicitly references prior juvenile adjudications and distinguishes between co-defendants. That individualized assessment is critical. Courts are required to evaluate each defendant separately. Here, the court concludes that the combination of alleged armed robbery and documented juvenile conduct outweighs arguments for significant bond reduction. Bond continues. The defendant remains detained. These early bond rulings often influence plea dynamics later. Pretrial custody changes negotiation leverage.
Okay, Judge. Thank you.
Thank you, Your Honor.
Court calls case People versus Julian Ward. Yeah.
Christina Costantino appearing on behalf of Mr. Word. Sorry, Drew.
Julian Ward, present.
Judge, this is a date and time set for PCC. At this time, we would be asking to have this matter set for preliminary exam.
Okay, that's not. Just coming.
So this is the bonders. You wrote 2 emails. One asking for her bond back. The second one saying that she did not respond back. So
And she did not.
correct. Yeah, I think the bond was signed. Yeah. So I don't think
So you're looking for a preliminary examination in this case?
Yes, Judge.
And you said discovery is complete.
To my knowledge, it is.
People have their witnesses available to 6.
That is fine.
Preliminary examination in person, May 6, 2025. 9 a.m. before Judge Barry.
We now return to exam scheduling. A preliminary examination is where the prosecution must present enough evidence to establish probable cause. This is not proof beyond a reasonable doubt. It is a lower threshold, but it is still a meaningful procedural checkpoint. Defense attorneys sometimes use exams to lock witness testimony early, explore inconsistencies, evaluate strength of identification, increase negotiation leverage. Setting the date moves the case into evidentiary testing territory. The courtroom rhythm continues: resolution, adjournment, exam setting. The judge maintains pace, efficiency with structure.
Bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Thank you, sir. Court does call the case of the People versus Stefan Scott.
And then on behalf of people,
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Scott.
Your name, sir?
Stefan Scott. Your Honor, asking for a brief adjournment to review discovery.
Probable cause conference, May 6, 2025. That's a Tuesday, 9 a.m. Bond continued.
You can't move forward without all this. Thank you, Your Honor. Appreciate it.
Court does call the case People versus Marika Philpott.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Ms. Philpott.
Ms. Philpott, can you state your name?
Who, me?
Yes, ma'am.
My real name is Teresa, but I do go by Marika.
Okay, we'll work with that. Okay, what are we doing?
Your Honor, I have to ask the court to adjourn this matter. I do have a green sheet. I did seek to visit Ms. Philpott yesterday. She wasn't up for company.
Okay,
If I could approach.
yes,
But I will go visit her again for the next hearing.
all right. I'll adjourn this matter to May 6, 2025, 9 a.m. That's a Tuesday. On continue.
And Ms. Philpott, I'll come visit you, but make sure you come up and see me, okay?
Hey,
Thank you.
All right, thank you, Ms. Popo.
yeah. What the hell?
Court does call the case.
Hold on, let me mute you.
Court calls the case, People versus Anthony Taylor.
Morning, Your Honor.
Morning, Your Honor. James Fifelski on behalf of Mr. Taylor, who's to my right. Please state your name.
Anthony Taylor.
Thank you.
Judge, I believe all discovery is in. We are asking the court to set this for preliminary examination.
Your Honor, may we approach briefly?
Why? Well, who's coming up?
Myself and Ms. Willenberg.
Okay, Ms. Willingbring's coming, then yes.
I do.
You may come up. All counsel has indicated all discovery is complete in this matter. And we were discussing dates. I'll set preliminary examination in person, June 3rd, 2025, 9 a.m. That's before me.
This scheduling stands out because it pushes the exam further than others. That may reflect calendar congestion, attorney availability, or case complexity. When counsel approach the bench briefly before setting dates, it often involves witness logistics, officer scheduling, or coordination between co-defendants. Exams require live testimony. Officers, victims, or witnesses must appear. Scheduling is strategic. The judge sets the date and moves forward. This courtroom operates with a steady procedural cadence, minimal drama, maximum structure.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you.
I'll stop by and chat with you. I'm requesting for the house. I'll try to stop by and talk to you.
Huh? So cool. No, it's one of the ones with the big flat. It's gonna be, because you like those, so. You don't know? Oh, so if it shows up, you might like run out. Never mind. We'll talk later. Let's call the case. People of the State of Michigan versus Todd Emmerman. That would be fun.
I love this job.
Good morning, Your Honor. Jennifer Douglas for the People, P72748.
And good morning, Laura Yagi, Assistant Public Defender, sort of with, but mainly on behalf of Mr. Ammerman. Your Honor, Mr. Ammerman is on Zoom. I was just trying to be in a breakout room with him. My understanding is he's not in Your Honor Zoom. He's in Judge Freshour's Zoom.
Oh, that works.
It does not.
I know.
I don't know what's going on. I was,
okay. All right. It's okay. Yeah. So what do you need to have happen? You need him to get to my Zoom.
This moment highlights the technological friction of modern court systems. The defendant is in the wrong Zoom courtroom. Virtual proceedings increase access but create coordination challenges. Defense counsel requests an adjournment not only due to location confusion, but because additional preparation time is needed anyway. The prosecutor does not object. The judge grants the adjournment. This is procedural practicality. No reason to force a flawed appearance when rescheduling resolves it cleanly. Even small administrative missteps can affect due process. The court handles it efficiently.
So, Your Honor, I was going to ask for an adjournment anyways. I did fill out a green sheet. I would ask for an adjournment and to allow us time to get him in the right place and to get him here.
Judge Freshour staff is not able to communicate well with him to get out of their Zoom.
What's that? He won't get out of there.
They tried to send him text messages.
But
So have you talked to him about signing into this Zoom?
I have not. I have attempted, but I have not been successful in.
Okay, because Judge Freshour staff, I was just informed, are trying to communicate with him to get him to sign into the right Zoom. It's not going well.
Yeah, that does not surprise me.
Well, okay. Appreciate your candor.
I really don't know what is going on, but
Shaggy, I'll let you out the hook.
Thank
Is there any objection from the people to the brief adjournment?
Your Honor, there's no objection. I don't have any information that suggests that the agreement is taking place.
All right. I mean, he theoretically, I guess, is next door, so he. All right. It's been 1 week out. Can you explain this to him in a week?
I will do my very best.
All right. Probable cause conference, May 1st, 2025.
Thank you, Your Honor.
You're welcome, Ms. Aggie. Court calls case People versus Quentin Williams.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Wendy Burnwell, P42505, on behalf of Mr. Quentin Williams.
Your name, sir?
Quinn Williams.
Thank you.
Good.
Okay, what are we doing?
I'm requesting an exam, Judge,
All discovery is complete.
upon information and belief. I believe so.
What's that mean?
I have electronic as well as paper discovery, Judge.
You're not available the week of the 6th, right?
One split second, Judge.
Well, you just looked it up before. It said,
Yeah, I have to look at the actual thing.
go for it. I was trying to be nice.
I'm available on the 5th.
Okay. But we won't be here on the 5th.
Oh,
Well, I'll be here, but we won't be holding exams on the 5th.
okay.
It's the 6th or the 13th?
One split second, Judge.
I know the answer. It's gonna be the 13th. Because you're not available the 6th, because we've already gone through this. But that's okay, I'll wait.
Donna, can you guys do it on a Friday?
Can I do what?
I'm available on the 9th of May.
Okay, good.
I mean, jury trial on the 13th,
Okay,
so I don't want to call that.
we do exams every Tuesday.
Okay. The 20th. Come on now.
People have no objection to that.
When I'm available, guys, I'm in trials.
Preliminary examination, May 20th, 2025, 9 a.m. That's before please. Judge Barr.
Available there.
We'll continue. Thank you.
Okay.
This courtroom session revealed the layered mechanics of pretrial criminal proceedings. We witnessed a negotiated plea eliminating a felony, multiple preliminary examinations scheduled, discovery-based adjournments protecting preparation rights, bond arguments shaped by domestic violence allegations, juvenile history, and robbery charges, phone privileges revoked after alleged witness contact, individualized bond determinations differentiating co-defendants. Judge Simpson maintained procedural discipline throughout, focusing on compliance, risk assessment, and structured scheduling. No verdicts were rendered today, but foundations were laid. Exams will test evidence. Bond rulings will shape negotiation leverage. This is how the system functions before trial: methodical, incremental, and consequential. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.